conference so far. Today's event is mitigating the risk, the 3 L's, legalities, liabilities, and the art of listening. Making a diligent judgment of what musical sound-alikes are, mitigating copyright infringements, and understanding some of the very important court cases that have occurred in the past 40 years, and understanding the chain of responsibility is absolutely critical and essential for a safe road ahead. After all, the last thing that any of us need as composers or music publishers is a copyright lawsuit. It's a very grueling process, not that I've gone through it, but it's a very grueling process, and it's very depleting, and it's the last thing that we would all want to have to do. Yet, okay, I'm hard. Thank you very much. Sorry about that. How's that? Should I start over? No, we're okay. Okay, anyway, apologies. Yeah? Yet what seems to be a normal sort of copyright infringement, as we would call years ago, is constantly evolving. And therefore, in addition to that, we now have infringements that are associated with stylistic elements. So it's really important to sort of understand how things are judged in terms of musicality as a composer and also as a publisher. And of course, now we have this new disruptor in the world called AI. So things are probably going to get a lot more complicated. We have a brilliant lineup of panelists here today, and it's my honor to be on the same stage with them. We have Peter Anderson, copyright lawyer, and partner Davis Wright Tremaine. We have Judith Finell, and Judith is a musicologist and also the president of the Judith Finell Music Service. We have Alex Black, chief executive officer from Sonoton, and we have Brad Marrapodi, vice president, Sync Catalogue and music production, BMG. I'm Art Phillips, your moderator. I have a business in Sydney, Australia. It's a music production library called 101 Music. I'm represented across the globe. So it's in my best interest to make sure that my copyright is clean and clear. And also, as of 3 years ago, I am now a production music distributor in our own territory of Australasia. Have something like 80 catalogs, 400 and something thousand tracks. So for me, this topic is very close to my heart. I think it's really important that you are all aware of it. I'm very passionate about it. I'm also probably overly paranoid right, about it, which I think we should be. We are constantly finding copyright infringements in some of the catalogs that we are representing, and we pull them immediately and inform the publisher. Okay, it's really important, everyone, to be prepared, aware, and vigilant, and to be really, really smart about what you are representing, whether you are a music composer or a music publisher, a label, or you are representing other catalogs in your respective territory. There's 3 things that are really important, and that's accountability, to be very diligent about what you do, and to act responsible, of course, in terms of what you are representing or what you are creating. The chain of responsibility, as everyone would probably know, I just thought I'd put this on the board, actually starts with the music composer. And of course, the music composer gives a warranty to the publisher that represents them, whether it's production music or whatever. And then that music publisher, if they have a sub-publisher overseas, also gives a warranty of indemnity to the sub-publisher that is repping. So it all starts with the composer. That's pretty clear. Everyone probably knows about that, but I just put it on the screen to clarify things. The next slide shows the chain of responsibility of the lawsuit. It's actually totally in reverse. As you can see, the alleged copyright being infringed, they would go to the original songwriter if it was a commercial recording, probably, or the publisher. But if we're talking about sync catalogs and production music in particular, for some reason the slides just vanished. There we go. Because it's sync, they're going to go straight to the client, so the client's going to get sued. So for example, it's McDonald's that used a piece of music that is allegedly like something else. That first lawsuit is going to be with McDonald's and the ad agency that actually worked on the campaign for McDonald's. So the chain of lawsuit is totally in reverse than what would happen in terms of the chain of responsibility. And it gets very complicated then, because then the sub-publisher is brought into it, and then after the sub-publisher is brought into it in our territory of Australasia, we somehow or another, APRA AMCOs get involved with a lawsuit, so it becomes a real long, convoluted process. Anyway, so our panel discussion today, I'm absolutely honored to have these guys and Judith on this panel. The first question actually is, what advice can be given to you to help best police infringements, whether you are a composer or you are a music publisher? And I guess the first question, I'm going to put it out to Brad. Yeah.
Sure. For me, the best policy starts with communication, so being really clear to composers, artists, writers about what we're looking for, what the brief means, how to interpret it, and what we're definitely not looking for. So we're being really clear that references and creative language may be referencing certain bands or artists should be taken as a whole across an entire brief, and you should never really lean on a one-to-one example, and just making sure that they're aware of that and what you're expecting from them.
Okay, so Alex, yeah, from your experience, what's the best advice you could give on policing?
Well, I think, first of all, it's the relationship with the composer. And it's getting an understanding with that composer on what your expectations are and where the lines are in terms of what they're producing. But I think things fall through the cracks. I've had experience where a track we received was identical to another trailer track, so it wasn't a famous track. The composer swore he had never heard of the library, never heard that track, but it was note for note identical. And you have to, in those situations, it's more about the team. We were talking about this earlier. It's once we've produced a piece of music and signed it, if the composer doesn't know that they've copied something, and maybe our internal producer doesn't know, at the point that we are then, the next stage of it is we've got a mastering engineer that we use for everything we do. He might hear something, or if it goes through that chain, then we're into our data team and they're doing the upload, they listen to it, they might hear something. So all the way along the line, all the way through to we can release something and be unaware. But, you know, our partner in America is APM have in times come back to us and said, you do realize that this is close to that. And, you know, so anywhere along the line, you have to use reason and use your ears and use your point of reference, I think, you know. So, but it all stems down to actually the relationship with the composer and whether we as a commissioning company, we as the publisher commissioning a work, whether we are comfortable and believe that the composer is abiding by the contract, you know. And if they don't, they've indemnified us. So it will blow back ultimately on the composer anyway. But it takes a whole army, you know, it's the whole infrastructure really in terms of policing.
Yeah, that's right. So that's with the Sonoton catalog, I guess, where you know, are working with composers and you're checking their works. How about all the other production music libraries that you do represent? When they deliver to you and they ingest into you because you represent them, do you listen to every track from your sub-publisher, from your publisher? Not
every track. I mean, we're quite a big sub-publisher, so we have about 100 labels. So not every track, but again, my team that are doing the catalog ingestion to get onto our website, the guy that tags a lot of the tracks that come onto our website, there's lots of kind of points along the chain where things can be flagged. Not everything is flagged. I mean, one of the big things I think within my company and the way I build a team is to ensure that you've got a lot of people with varied points of reference musically, right? So you have more chance of picking up the nuances of a particular style if you've got someone who's into that style. But when it comes to third-party repertoire, it's difficult. You just have to be as vigilant as possible, and then take stuff down when you find it.
That's right. Yeah, I mean that's what we do as we find stuff. So, do you have a team of people at BMG that actually listen to other catalogs that you represent?
Yes, we really utilize the entire team to keep their ears and eyes open for anything that could be possible infringement. So it may come from production, it could come from a person on the sales team or the creative team or operations, and they'll flag it for the team and we'll do an internal review.
Yeah. I mean, it's a lot of music to listen to. You know, I mean, if you rep catalogs, so you have over 100, I have 80, whatever, and other people have whatever. It's a lot of tracks to listen to every time you get a new delivery, but it's really important that you do that, isn't it? Yeah.
Yeah, but I think as much as possible, it comes back to that same relationship we have with our own composers. You know, we need to have those relationships with the catalogs we represent. And you know, bad actors need to be, you know, you end up not doing business with them, right? It's about, this business is a lot about trust. And, you know, you need to develop those relationships, develop that trust. And over time, you kind of work out what's going to work for you and what's not in terms of third-party repertoire.
Yeah, no, interesting, yeah. I was speaking to somebody, I don't know, it was about a week ago, saying, you know, that I had this panel that we're doing here, and, you know, how interesting I hope it's going to be for everyone. And they said to me, well, what are you so worried about? And I said, well, you know, copyright infringement. I mean, I don't want to go to court, and of course, you know, blah, blah, blah. And they said, yeah, but don't you have insurance for that? And I said, yeah, we definitely do have insurance, but why not mitigate the problem before you have to get the insurance company involved? I mean, it's like if you own a fruit and vegetable shop in the Italian, you know, place, you know, and you don't protect your floor with, you know, soft walking rubber instead of concrete floor and slippery paint. That's mitigating the risk. That's what. So, I just wanted to point this to Peter. We had a bit of a chat earlier today. And I was just wondering if you could talk about error and omissions insurance that you have here.
Yeah, well, as Alex said, you know, mistakes happen. And if you're dealing with hundreds of thousands of songs, what you need is errors and omissions insurance, which comes in if there is a claim. You can have indemnity rights against someone else, a composer, for example, but that's only meaningful to the extent that the composer can answer for the indemnity claim. Insurance companies provide coverage for mistakes. And so I can hear an echo, but so, you know, it's important to have errors and omissions insurance as a backup in case something comes up. Many claims, you know, in our local federal court, 95% of cases never go to trial. They get settled. And usually that involves some kind of a payment. It can be nominal, it can be significant. But if you've got an insurance company backing you up and paying the attorney's fees, you're in a much better position if something does get missed. And technically, they're not that, the premiums aren't usually all that extensive. And one of the things that I've seen, I've been doing this for a long time, and one of the things that I've seen since Blurred Lines is I've seen recording artists getting insurance for relatively low premiums. And so most of the recording artists that I represent have errors and omissions insurance. 20 years ago, you never saw that. It just was unknown. So, you know, and I think that makes sense. You know, as Alex said, everyone's going to ultimately look to the songwriter. So if the songwriter doesn't have insurance, you know, that could be a pretty big bill.
Yeah, I mean, it's absolutely critical to have this insurance, for sure. I was telling Peter and Judith a story about, in Australia, we don't have error and omissions insurance. We have something called public indemnity, which is basically the same thing. But my lawyer and I had a really good look at some of the clauses because I'm Mr. Paranoid, and we found out that there was an exclusion, and we had no idea what this exclusion was. Now, this is just my insurance policy in Australia, and we've contacted the insurance company, try and get them to alter it. There's a warranty that we give if we issue a license to a client, and if we're sued down that chain of lawsuit that you saw earlier, that the insurance won't cover that because in our warranty to the license, and AMCOS also issued the license on behalf of us who represent blah, 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 we aren't covered. The only time that we're covered is if you, the composer, are suing me as a composer, if it was on commercial radio or whatever, it would take care of that liability, but not when you issue a license for sync. So I have to do some work to find a better insurance company, obviously. Yeah. Peter, any advice there? Judith,
if I might add, so as a musicologist, you know, we receive a lot of requests before something's released because the studio or the ad agency or whoever's using music has to show some form of due diligence even to activate their insurance. They can't show that they really made no effort to avoid copyright infringement. And we're often asked to, for example, before something's released, give an opinion about whether or not a piece of music, say, is in the public domain, is going to be used in a commercial, it's going to be used in a film, it's a Christmas carol. People say, oh, of course it's public domain. I heard it since I was a child, you know. Well, but this is a modern arrangement. You know, Mariah Carey happens to be singing it. What you have to see is what in the new version is not in the public domain version. There's an analysis that needs to take place. And that's where, you know, the analysis can protect you before, because you can sometimes remove the non-public domain features if you don't want to license the modern arrangement. But you do have, I'm often told by the clients that they want that report in their file to show that they did what they were supposed to do before using that song without licensing it, for example.
Yeah, no, right. So I mean, it's another way of, is this still on? Testing, yeah, it's still on. I mean, it's another way of actually mitigating to have the insurance, but I still think that the best way of doing it is really mitigating, you know, what's going on. It's crazy, yeah. The other question or sort of item that I have up on the screen next is the importance of being vigilant with your metadata. And you all know what metadata is, of course, and composers who don't, you'll be doing that if you do production music, of course. Really, really important. And we certainly don't want to be saying something in our metadata that this sounds like, you know, Pink, or sounds like, you know, the Rolling Stones or something like that. And as soon as we see that, and I send notices out to all the publishers I represent as a sub-publisher to clean up your data, it can't have that, because that is, as we talked about, an admission to guilt, really. So, Peter, do you want to take that, and then Alex?
Yeah, I would just say a couple of things. One is that copyright infringement, at least in the U.S., requires that someone has copied protectable elements of a song. And so when you're going through a copyright infringement claim, you have to prove copying, which usually requires that the songwriter had some access to the work. If you title your track referring to a work, you're admitting you had access to it. And also, on sound-alikes, all sound-alikes are not necessarily infringements. They may not copy the protectable elements. That gets into, you know, a deep analysis both on the law and the music. But, you know, so in theory, you know, someone could say, you know, I did something that sounds like X and be proud of it. But from a litigation standpoint and from a musicology standpoint, it's probably not a good idea, because you're admitting, that person is admitting that they know about this other song and they were trying and endeavoring to sound like it. Whether they cross the line is another issue.
Yeah, Ellis.
Yeah, no, I'd agree with Peter that it's intention, isn't it? So I think, in my experience with infringements, I've never had there's not a black and white answer to what is infringing and what is not. There's a lot of subjectivity, and especially here in America, depending on where you are based and what the court is and all of those things. But the same in Europe, where I'm from, to a point, it's subjective, and therefore it's a smoking gun if you are referencing a track. You know, it shouldn't. If you were intending to make a sound alike, then be more creative with the titles. And, you know, and certainly if you're a library and with metadata, you know, avoid the references, because these things just lead. I mean, in the data age we live in, you know, the ambulance chaser lawyers who are looking at this kind of, you know, these kind of infringements for certain artists, just have to put the name into a search engine, you know, or the song title in, and if you've referenced it in some way, then you're going to ping up. And then if you happen to have got too close to that song, then you're in trouble, right? And so it just isn't necessary to have lazy titling like that. And we certainly clear out any of that within our catalog. And if we're representing a third party that has a lot of those references, we remove them.
Yeah, Judith, yeah.
If I may, just One of the things I would say in terms of sound alike, it's also used in a different way in terms of sounding like an artist. And so say, you know, in your library of production music, you have a sax, you know, a sax melody, and, you know, you want it to sound like Kenny G. He has a pretty distinctive sound. And so, you know, it's important to evaluate that, not only in the metadata or in the way you market it, in terms of, you know, maybe somebody says, well, I want something very cool and relaxing like a Kenny G song, and then you go out and get a saxophonist who plays with his specific way of using the instrument, you might have a problem. So, I mean, you have to be aware of not only the song, but the artist that you may be imitating. There are cases involving not copyright, but more right of publicity, such as Bette Midler's distinctive voice and all. So there's more involved than only the composition.
And I think it's also more than just having references to artist names. It's also like famous TV shows or films. I just don't think we should go down that route. That's my theory, because, you know, I mean, it's better to be safer than sorry. There was a case in Australia with Men at Work. I don't know if you know who that band was. This is back, I think, in the 80s, yeah? Where on the recording, there was a really cool flute riff, and the flute riff was the exact ripoff of a nursery rhyme called Kookaburra Sits Under an Old Oak Tree. A kookaburra is a bird that we have. We have oak trees, too. But, yeah, they won. And poor Men at Work, you have a story, I can tell.
Well, I know Colin. But,
yeah.
But the story, the part I was going to tell was the way it came about. That song was actually done without that introduction.
Yeah.
And then they brought in someone who wasn't a member of the band and said, well, how about this? And they thought, yeah, that sounds good, and they added it. So it really is sort of a quintessential kind of example of a separate composer, you know, contributing something that ended up blowing up in their faces.
No, that's right. And that poor musician who's now sadly passed away, it was a horrible thing for him. I mean, he was just a session musician. He came in and played the riff, very cool, but boy, you know, things happen. Yeah. So anyway, interesting topics, I think, yeah. We've already talked about this a bit, so I'm not sure how much more we're going to go through with this, but keeping an eye on what's really contained in your catalog and the art of listening for infringing substances, and we've already talked about how we actually do this. It's important to have a team of people. My question actually is to one of you, I guess Alex or Brad really, is when you do get a new release from a label that you rep, before you release it, you know, do you think it's a really great idea that we all sit there with a few people and make sure that there's nothing infringing? And how do you handle when you sign a new catalog with, you know, 100 albums or something, and you starting from scratch?
Well, signing a new catalog, we really do a thorough review of the music. So if there's 100 albums, we're not going to listen to every track on every album, but we will listen through some music on every album. And I think you can get a sense. If all of a sudden you start hearing several sound-alikes across several albums, you start to form a picture of it. And then, you know, in terms of policing what's already out there, what's coming in new, our team is just really encouraged to be listening for things like that and bring them to our attention.
Yeah. Right, Alex, do you want to say something?
Yeah, I mean, it's just listening. I think you've got on their AI tools. I'm not so sure that there's any real tool at the moment.
Yeah.
For me, all the chatter around these detection tools, I'm not convinced about. So nothing beats having a broader sphere of reference, knowing music, and knowing the source. You know, it comes back to relationships. I wouldn't. Typically now, I don't sign a catalog. I don't sign catalogs very often. But if I do, there's usually a deeper personal relationship with the owner, and it becomes about trust.
Yeah. So, you know, the value of AI, of course, there's pros and cons, and I think there's a lot of cons, but the pros obviously are that most of us as publishers who rep other libraries have a search engine that has AI on it. And it's very helpful, you know, with searching, because it's better than keywords. We can drop in a YouTube link or a Spotify link or MP3 file, WAV file, and it'll find tracks that we represent that are sort of like it. And it keys up, you know, audio, sound, and also it searches that way, and also with descriptives and keywords. And we also have the ability to put in, you know, a prompt search. We can actually say, you know, sitting by the fire, drinking a margarita on Christmas Eve, and it'll come up with some tracks that actually sound like it could work for that. Hopefully, that's what it's all about. And there's some good and mediocre search engines, but AI search helps. But one of the things that we're all lobbying for and looking for and hoping for, we're not sure how it's going to work, is if there are going to be any AI tools that can detect whether any of the music that we represent or we're getting from a composer was created by AI. And I think that's a really important item, especially if you have a principle, like I think a lot of us do, is that, I particularly don't believe in representing any music that was created with AI. But then, there's going to be a fine line there, because maybe there's going to be some tools that are useful, that aren't dangerously infringing, What's your thought on that, Brad?
I think AI is great as a tool to help you. When it's for a search function, it's going to help you do that job quicker and more efficiently, but as long as it's not a generative AI tool. So we don't want any generative AI music in our catalog. So looking at it more as something that helps you do the job that you're doing quicker, better, maybe more efficient. But it starts with a human, it ends with a human.
Anyone else?
Well, I would add that I think I may be jumping the gun in terms of the questions, but it feels like the right time. We in our contracts with our composers, when we're commissioning composers, there is a clause in the contract where they are signing to say that they have created all aspects of the musical composition. So again, it comes back to that indemnity. It comes back to the relationship, but the reality is, a long time ago, we stopped composers using Splice or any other sample library out there for using that for anything more than one-shot hits. That was because that particular website was so popular that I think when I was at EMI, we were producing about 200 albums a year. We ended up having 3 albums in a space of about 3 months with the same vocal on it. And they were produced by different teams in different places in the world. And it was just, and at that point, this was about, I don't know, must have been about 10 years ago. At that point, we just put that in the contract. No more. We can't do it. But that human composition aspect is there in our contracts now. And that covers, I feel that covers the aspect of you cannot use AI to generate a melody, generate a vocal top line. We don't want it used as a singer. We want to employ singers. This is our stance. And when it comes to, if I would not sign a catalog to represent if I had any inkling that they were trying to fast track their creativity that way. And if any catalog I currently represent starts to do that, I will terminate the contract straight away, because it's just not in my business's interest to do that. Everyone has to make their own creative choices, but my creative choice is that I'm not playing that game.
Yeah, well, I totally agree with you, Judith.
I would also point out that the United States Copyright Office does not recognize machine-created musical works. And so right now, one would say, well, what if part of the song is created by AI and part of it is a collaboration with the human? Well, start thinking about what is life plus 70, for a machine. I mean, there's a lot of challenges now to monetizing it, and especially if organizations like yours won't accept machine-created material. But it is a tool. It does have its use. And it helps even disabled musicians, by the way, compose in ways that they never could have been. Some of the work that's being done in AI labs, such as MIT Media Lab, I mean, it's revolutionary what AI is doing for people in the field of sound.
No, that's right. So Peter, do you think, are you worried, are you concerned, are you happy that with AI there may be a lot of new type of copyright infringement disputes that come in? Do you think this will really affect that part of the...
Right now, as Judith said, the U.S. Copyright Office does not recognize a copyright in AI-created material, and my understanding is that even if there's a... Sorry. As Judith said, the U.S. Copyright Office presently doesn't recognize copyright protection for AI-generated material. My understanding, and I could be wrong, is even if it's partially human created, partially AI, it's not protectable. And so, it creates that problem, but there's also the problem in the ongoing litigation where you have to train AI. And so apparently there are allegations that AI is trained by, in effect, allowing it to copy and manipulate the sound recordings and musical compositions of existing artists. So basically, the dispute going on now focuses on fair use. Is it a fair use to, copy a Mariah Carey recording in order to create something that's actually different than that recording, but in the process you've copied and exploited a copyrighted work. So there are multiple cases across the country involving this, and as of now, no legislative action by the U.S.
No. So Right, the only thing I want to add is we're very lucky that our PROs across the globe also will not recognize anything that was actually created by a machine learning, I believe, right? So the Copyright Office too, which is fantastic. So hopefully we will all be okay, we hope. Yeah?
Can I add one thing about indemnity, because it's come up a couple of times. There are two main types of indemnity clauses. One is that if a claim is made, the indemnitor agrees to take over the defense and do all that. The other is that if a claim is won and there's actually a judgment that you've infringed, then the composer comes in or whoever grants the indemnity. And that's very different. I've got a case now where my client is being sued for infringement, but the company that actually did it is happily saying, well, and I didn't negotiate the clause, but the indemnity clause requires a judgment. So they're basically telling us, let us know when you lose. So it's basically useless at this point.
Well, that's funny, because my next question is actually fine-tuning your liability clauses for things that you represent, any contracts that you come into. That was perfect timing. Thank you. Yeah. You must have practiced this. Yeah, fine-tuning liability clauses, how important? I mean, if you'd like to talk to it, we all know what those clauses are sort of all about, but do you think that it's a good idea for, recommending to publishers and sub-publishers nowadays to have clauses in there about, AI detection, and we don't accept that, even though we are indemnified anyway with our current agreements? Should we be much clearer and point to specifics?
Well, clarity is always important. When you get to litigation, you're dealing with lawyers whose, art in life is finding ambiguity where everyone else would think there's clarity. So you want clear provisions. You might have this struggle. One side might want the indemnity to kick in only if you lose. The other side wants the indemnity to kick in even if there's a frivolous claim. So, it depends on which hat you're wearing when you're negotiating it. But clarity is always crucial.
Yeah, great. Alex? Yeah.
I was just going to, absolutely clarity. So, we've just redrafted all our contracts for the Sonoton Catalogue going out to our agents and partners and any supplier that we supply in the chain anywhere. And to say absolutely no AI training is allowed, you have to spell it out, I think. And I think even though, our current composer contract leans on this kind of a human has to create every aspect of the copyright, we are looking at adjusting that to really spell out that means, no AI.
Yeah. Yeah, really smart idea to make sure that you're covered left, right, and center. As I said, I'm Mr. Paranoid, so I think it's really, really important. When we are looking to see if something is out of copyright, what's copyright law now here? 75 years, is it? Yeah. After the last composer's passing? Yeah. Or 70. Yeah. Not 75. Yeah. And so when you're looking to find out if something is really okay to release and to redo, where's the best place to search besides just going to your PRO, I suppose, and asking them to help you search? Is there a good place to search to find out what's really in public domain?
Yeah, I think for myself, I start with a place like pdinfo.com, which is a kind of broad resource and database. And then from there, I'll do some more research on the internet, finding some of these timelines. And I might even utilize AI to do some more research, like Perplexity or one of those that is very research-based. And then from there, try and make a decision. And if I still have questions, I might loop in some of our legal team for their advice. And then if we still can't make a decision, we reach out to someone like Judith for an expert opinion from a musicologist.
And I'm correct, I think, that for some reason, some copyright in certain territories or countries is still in copyright as opposed to some being out. How can that be? Why can that be?
You asking me or her? Or him?
For Peter, I think it's probably...
Well, the U.S. copyright law stops at the border. It's a little bit more complicated even in the U.S. because corporations, employers of works for hire, have a different term. I think it's 90 years after creation or something like that. And so, but the U.S. copyright law stops at the border, so then you have to ask a couple of questions. Well, what's the law, where the composer was born and died? What was the duration of copyright there? And then you have to ask the question, well, is that changed by the Berne Convention, which is a multinational treaty? Then you have to ask the question, is there a bilateral treaty that somehow extends the life? And I had a claim years ago where my client's book was in the public domain, but not in Germany because of a bilateral treaty done like after World War I or something. So it's a very, very complicated process, and I'm happy to say I am not involved in any of it because it's crazy to try and figure out, well, what's the law in Germany or whatever.
So do you think it's important for us, before we happen to pass this lifetime, that we look and see what country is the best place to go and settle in to make sure our copyright lasts long? Anyway, Judith.
I just wanted to say that determining if something is public domain is extremely complex. I mean, I have a team of 6 doctoral level musicologists. We get an assignment like that. It takes many, many, many hours. Yes, you can start with a database, but remember that a song has a whole history. If it's the words and lyrics often have different histories. We're talking about old songs. People say, oh, it's traditional, right? It's a children's song. Well, not necessarily. First of all, how old are the lyrics? When did they change? Because it could change in another culture at another time, especially if it's folk music or protest music or addressing some sort of political agenda. It could keep changing. That doesn't mean the melodies change, but the words might change. So you've got sort of a moving target. So just finding out the oldest version of a song and the oldest version of the tune and the words is a first stop, but that doesn't mean that subsequent versions aren't still protected. So it's actually pretty complicated.
And then you have to look at if something is in the public domain and recorded by the Czech orchestra or whatever, and if you infringe on that arrangement that they did that's specifically unique to that recording, that's also a copyright infringement.
Arrangements have their own protection.
Yeah.
And the converse of that, and I can't tell you the company or the composition, but about 10 years ago, a very well-known composition fell into the public domain. But when we checked, there were like 800 separately registered arrangements of it. So basically, the client could just sit back and target the new uses that copy material added to create a copyrightable arrangement.
Yeah, it's crazy.
Remember, Happy Birthday recently was admitted to be in the public domain?
Well, that's right. So is Happy Birthday in the public domain worldwide? Do you know?
Well,
well, I'll tell you why, because...
You can probably answer that quite well.
Yeah, well, do you want to say something?
The publisher lost that case. I'll say that.
Okay, yeah. Were you involved with that? Or?
No, I was not.
Anyway, okay. No.
They had many, many decades of earning money before they lost it.
Yeah.
Yeah, cool. Look, we have a series of questions here that I'm going to have Judith, our expert musicologist, talk a little bit about, before I show you some examples and talk about a couple of court cases. So strategies in terms of detecting problems and disputes, mitigating is so important, as we said. What strategies do you suggest using when communicating musical ideas and examples to a composer, for example?
Well, time is always at essence when you're commissioning a composer to write something for your film or series, video game, or commercial, for example, and we're in a town full of that. And the easiest way to communicate is with a temp track, especially if the director who's looking for a certain scene, syncs it up perfectly, and they really want it to be like the scene in Dirty Dancing, where, Jennifer Grey was lifted up, by Swayze, and the music that goes with it. And they'll give that to a composer and say, write something like this, but don't infringe. The first thing you need to know that, I don't know how many of you are composers, but it's very rare for a composer, even with serious, deep training in music, to have any background in copyright protection. It's not taught in any major music program that I'm aware of as a separate discipline. So telling a composer don't get too close has its problems in terms of what does that mean. But if you don't get too close, you turn it back to the director, and the director says, it doesn't feel the same anymore. Could you get a little closer? That's the problem.
Well, that's right. So I think what we would tell them is that, you know, if you really love that song, license that song, you know, really, I mean, it would be great.
That's always a good idea.
Yeah, Jerry Goldsmith used to say, well, he refused to even look at a film that had a temp track on it. So that was his position. Well, he could do that because of who he was, you know, amazing man and an amazing composer. So, yeah, I mean, temp tracks serve a purpose, as you talked about, and, you know, we talk about as composers. I don't mind listening to a temp track as a composer because it sort of helps me frame up, okay, that's sort of what they want. But as long as they're understanding that they hire the composer because they really want that composer, as opposed to, you know, it's important that we get that trust. Trust is what it's all about anyway, isn't it? So, yeah. So how close is too close? We sort of covered that, yeah? Myths and misconceptions, which I didn't know anything about this 2-bar rule or 2-note rule.
Right. Well, I get that question all the time. You know, people call up and they've already written the music and they say, we just want to make sure it's okay to use 5 notes, right? You know, from something else. Or it's okay to sample something that's less than a second long, or those kinds of concepts. Or there's only 7 notes in the Western scale, so of course this is similar to that. You know, the fact that it also has the same lyrics and, you know, the same chords is a little coincidental. But you see, so how close is too close? Well, first of all, there is that concern about, I think it needs to be reviewed by somebody with, you know, granular musical background, number one. But number two, that's still a subjective opinion, but a musicologist is trained to look at it sort of on a note for note, you know, bar for bar elements, see how many there are there, and then present that level of risk to the client to make an informed decision.
Yeah, great. Okay, so we have 7 notes, as you said, you know, sort of in the scale or note names, but then we have all the sharps and flats in between. We have 12 notes, and then, of course, we have the Bosendorf piano that actually has, 4 extra notes or whatever. So we have a lot of notes, but they're all, so yeah, what happens in the octave situation, you know, sort of in chord? I mean, do they talk about, you know, yes, those notes of the melody are the same, but it actually went up the octave over here, so it's not an infringement? Or
you mean you're saying like it's in a different register, but it's the same tune?
Yes, exactly. Yeah.
No, that's, if it's copying, it's still copying. You know, it's like saying, well, the soprano sang, you know, Oh Holy Night, you know, in a high range, and the bass sang in a low range, still Oh Holy Night, right?
Okay, yeah, right. It's a whole study in itself, yeah? I just put these up as some example famous copyright cases. 2 slides. We're not going to look through them all. However, one of the first ones I wanted to talk about, and this was Peter Anderson's success story, I suppose, is the Stairway to Heaven case that I think happened back in 2014 or 15 and went on until 2020, yeah? And you were involved with all of that. Just wondering if you wouldn't mind recapitulating what that was all about and what the result was.
Sure. I tried that case and argued it on appeal. And yes, sorry. I tried that case and argued it on appeal. What it was the estate of a songwriter who was a member of the group Spirit sued, claiming that the introduction of Stairway to Heaven was copied from an instrumental that this guy named Randy California had done. This claim was made 45 years after Stairway to Heaven was released, and they could do that because the U.S. Supreme Court had, 2 weeks before they filed, ruled that latches wasn't a defense, delay alone wasn't a defense. So the claim boiled down to both songs had a descending chromatic scale and a commonplace chord progression. And the plaintiff, this wasn't one of those cases where someone said, well, the melody's, you know, the same. It wasn't, other than the descending chromatic scale. The plaintiff argued, that you can get copyright protection in a selection and arrangement of unprotected elements, like a descending chromatic scale, which is just running your fingers, I think, right to left and hitting the white and black keys on a piano. And so what the plaintiff argued was that Randy, California, had created a protectable composition that was substantially similar to Stairway to Heaven because both had a descending chromatic scale, both had a commonplace chord progression that isn't protected, and in both songs there's a place where A goes to a B, C goes to a D, and E goes to an F, something like that. None of them were consecutive. So it was basically just random similarities picked out of the first 4 measures of both songs. The jury agreed that there was no infringement. On appeal, eventually there was what is called an en banc decision, which is 11 judges hear the matter, and the ruling that they issued is binding in the Ninth Circuit, which is the federal circuit we're in. That circuit and that decision established that you can't have a selection and arrangement claim of just random elements throughout a song or throughout a part of a song, which is basically the most difficult kind of claim to police because you're not hearing a melodic similarity. There are no notes that are consecutive that make up a melody. There's just a random pitch here and a random pitch there and commonplace chord progression. And so it's not something you can actually listen for and hear. The other thing that they ruled is that you can't get copyright protection in 3, 4, and maybe even 7 notes in a row, which is melody, and that if you do have a selection and arrangement claim, it has to cohere into a new musical design. It was followed by another case, a Katy Perry case, that ruled that just consecutive notes aren't copyrightable. So there are some guidelines in the sense that, at least in the Ninth Circuit, 5 notes in a row is not protectable, but it keeps open this argument of selection and arrangement where you can pick and choose. Plaintiff can find 2 songs that have bits and pieces that are similar and then sue on the basis that these bits and pieces appear in both works.
So was that the Katy Perry case with A Joyful Noise against Dark Horse, or no?
Yes, that was it. And it was a repeating ostinato. Right. It was basically 2 quarter notes, I think, or 8
no,
notes.
No, it was 8 consecutive notes twice.
Yeah.
Wow. Okay.
And they didn't sound anything alike, which is interesting, although technically that's not relevant.
The ostinatos were exactly alike, actually.
No, I mean, to my ear.
Oh, the whole song.
The whole song,
but that had been just selected out to discuss. Yeah, that's
right,
true.
Right. And so the only thing you had was 2 repeating notes. And the jury found liability, but the judge then threw it out 2 weeks after the Skidmore decision.
Okay, so this next story, we're going to talk about how much money somebody actually got in the end result, and I'm going to hand this over to Judith, but it's about the Marvin Gaye estate who sued Blurred Lines, the song Blurred Lines, yeah? So. Right.
Oh, so I was in honesty, I was the expert for the Marvin Gaye estate in the Blurred Lines case. And this was a case of a substantial similarity of musical elements. The recording was not allowed to be heard by Marvin Gaye, was not allowed to be heard in the courtroom due to a technicality within the law. So when we were allowed to use the recording for the first year and a half before the trial, I had found 16 identical, or close to identical, traits in the 2 songs that wove their way through Blurred Lines in all but 2 bars of the entire song, a Pharrell Williams song. But after the recording was thrown out before trial, the similarities that were based on the lead sheet were 8 similarities. I described them to the jury as an intersecting similar features, a constellation of similar features that continued, and I showed them a chart because I wasn't allowed to play the recording, though I did play the piano for the jury. And in the end, the jury understood the relationship and that some of the similarities lined up exactly bar for bar, even in the recording, down to the millisecond beginning and end, to the point that it was said by another expert that it was as if Pharrell Williams used Marvin Gaye's song as a template for his song because they were lined up structurally and used the same same series of unusual features, which is called word painting, illustrating words, their meaning of words symbolically with the melody, and the melody was the same in the two songs in those. So there was some identity, there was some similarity, and it was a pretty big milestone case, I think, in terms of the jury award.
Yeah, well, Judith works in this, capacity, and she gets to bring her piano into the courtroom and actually play the piano. She has to do that, and also, I heard a story that she also had to bring a little drum kit recently, at some time over a court case. So, if things don't work out in the music industry, you can. Anyway, yeah. So there's a lot of examples. We're certainly not going to go through them all, but yeah, thank you for sharing those. Yeah, we have about 5 minutes left. And I'm not going to get through every one of my slides or all the other cases, but what I did want to do was just play you something that we recently found in representing some catalogs. And you all know the Phil Collins hit, sort of In the Air Tonight. I'll just play a bit of this just to remind you of. Anyway, we all know the song. I don't have to play on with it, right? I know you love it, yeah. Okay, but check this one out. You might like this better, right? So this is what we had to pull from our catalog, informed the sub-publisher right away. And the song happened to be called Purpose. It's had nothing to do with an admission to anything, but have a listen and you tell me what you think. It starts as a rap song, but it's not an infringement yet.
Breaking through the glass, my fireproof proof still sitting on the dash. Wanna break, but I'm told to keep my foot up on the gas. I can see you pacing through your room at night. But hold on.
Anyway, I had a heart attack, and I did. And actually, Emily Oliver, who is my head of licensing for 101 Music in Australia, is here, and I thank her tremendously for finding this one, because, we don't get to listen to everything, and if somebody happened to use it, oh, wow, this is great. We get to use, it's just like Phil Collins. Guess who gets sued? Yeah. So anyway, just really, really quick, what a musicologist would do, I'm sure, is actually go into court and put the chord progression up, and what they've done is use the same chord progression a half step higher in the infringement. Crazy. Hello? Crazy, crazy. Same feel, same chords, just one half step higher. That's not going to get you out of trouble. It's crazy. So yeah, and here's the melody from both ones. The upper stave is Phil Collins' track, and the exact melody up a half step. Exactly the same. Da 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 da. Anyway, I won't sing it. I don't sing. So yeah, and so this is what you have to do with sheet music and walk into court. I guess is actually prove it. But that was quite scary. I have this one other thing. It's a little game we're going to play for the last 3 minutes, if I can. Yeah. I just thought this would be fun. We also found something else, and happened to be Pink. All know Pink's song called "So What," which I used to think was called "Rockstar," but my daughter and grandkids said, Dad, Grandpa, it's not so, it's called So What. Anyway, so this label that we represent had a piece of music that I think, I'm not sure, I thought it was, and we pulled it, but when I was preparing the seminar, I am not sure. So first of all, I'll play you a bit of this. Okay, and the so-called possible infringement, and I question this, I'm going to have everybody listen to it, and then I'm going to ask for a raise of hands who thinks that it's a copyright infringement, and then I'm going to go to the panel, just talk a little bit about it. I might be wrong, but maybe it's because of my paranoia. You know the melody, you heard it. This is a song called Here We Come. I pulled it right away for our analysis. No? Okay, well, so a raise of hands who thinks it's a possible infringement. But not everybody. Okay. All right. That's interesting. I might be totally wrong. Here's the analysis. It's a triplet feel, as you can see, of her melody with the intro, and then the other one is not the same, but it's still a triplet feel, but it starts on the end of 3. 1, 2, 3, da dee da dee da. You know, compared to ba da 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 da. So, but I feel it was too close for comfort, and chord progression of the hook didn't really matter because that was not an infringement. So I don't know if I.
You haven't compared them in the same key, though. I mean, it would be hard for the audience to look at that and draw that conclusion. You got them in 2 different keys.
Well, they are in 2 different keys.
I know, but you have to transpose them to do the analysis.
Okay, yeah, right. Well, that's something that I learned. I didn't know. I'm not going to court. I'm not planning on going to court, so I wouldn't have known. But okay, so most of you feel it was not an infringement, yeah? And I mean, everybody. I mean, what would you have done if you heard that?
I think the melody was the thing that kind of stood out to me, that I would then transcribe the chords, look at how it interplays with the melody, take the song as a whole, and go from there.
Yeah, because the key word for me was similarity, really. I just sort of thought the same tempo, same vibe. When I heard it, I thought it's exactly the same. But then I realized months later, when I prepped for this, maybe I was wrong. Yeah?
Well, it's really in the notes, the pitches, the rhythms, and the harmonies, as well as the lyrics.
Right. So any comment?
Big 4.
Do you think I jumped the gun, Peter?
No, I would have analyzed it, but I just would have analyzed it a little differently, personally.
Yeah, no, it has to be transposed into the same key, I think, and, you know, you can hear some similarities. My initial reaction is that they're probably not in protected elements, that, you know, and again, maybe transposing them would reveal that they are, but, you know, you generally can't protect rhythm, you can't protect vibe, you know, you're looking for, you know, something more substantial that's copyrightable. But.
Yeah, right.
But melody is pitch plus rhythm, so you can protect rhythm, melodic rhythm.
Yeah, I was talking about the drum.
Yeah.
Yeah, but
The drum
yeah.
Well,
We agree.
okay. Well,
First time.
do you have one final comment? I was just going to.
I personally, I wouldn't have picked that as an infringement.
No, you wouldn't have. No.
I think there's enough distance between the two. It's certainly not an intent. They're certainly not trying to do a sound alike. And then, from a melodic point of view, I think it's sufficiently different, personally. But
Yeah. I probably had too much vino that night.
I mean, these things. A musicologist once said to me that if you hear an instrumental track and you sing a lyric to another song, you're too close, right? And a lot of this is just gut. A lot of this has to be your own intuition and gut feeling. You know, it's certainly if you're not setting out to do a sound alike. If you're just writing as a composer, you know, it's inevitable that you're drawing on references and you may get too close unintentionally, and it becomes just about. I mean, the first process has to be gut feel when you listen to something. If it reminds you of something else,
Yeah.
you know, which is why I think it's always a little sketchy when. On a technicality, you can get sued for. I got sued once for a copyright infringement where the music was nothing like the claimant's piece of music, but we still conceded because of a technicality, which is a nonsense to me because it's not really an infringing track.
There's always these fine lines. It's tricky business, and you know, I guess I don't mind being paranoid, and I promise that I won't drink any more wine when I pull something off my catalog until I'm really sure. Judith, I'll call you, and I'll do a deal with you, and you can help me listen.
I won't drink any wine after you call.
Anyway, look, first of all, I just wanted to thank all of you because you have incredible busy careers and schedules, and to come here today for the PMA event for me is just fantastic. So really, really, really appreciate it. Thank you to the audience. That's good. And I also just wanted to say we have no time for Q&A, of course, because I wanted to get the most golden value out of this brilliant panel. But if you have any questions, and if you see any of us around, you know, after the event, more than welcome to come up to any of us. Thank you very much. And thank you to the PMA.
Thank you.